we go to slides? 32. So with respect to the question about Justice Tulloch and whether the recommendations were implemented, I guess you can assume from the question or the answer that we're in dialogue with Meg that the government hasn't yet made decisions about exactly how many and in what way, but certainly the recommendations would fundamentally affect the structure of the Police Services Act, right? So parts of the Act that are there now with respect to the SAU and the Independent Police Review Director would come out of the Police Services Act. The way for dealing with public complaints, which is currently in Part 5, would come out of the Police Services Act. So the changes, which are certainly being actively considered, would be substantial. All right, so with respect to slide 32, this is describing the options with respect to delivering police services to First Nation communities that the Ministry and representatives from the Anishinaabe Nation, Anishinaabe Police Service arrived at last August. That process was called the Adequacy Standards Table, and so these recommendations are sometimes referred to as the AST recommendations. The first option for First Nation to receive police services would be to receive police services from the non-First Nation police service of jurisdiction. So if the OPP is the police service for the area, then the First Nation could receive police services from the OPP. I understand that's currently the case for 19 First Nation communities. If it's a municipality, then the First Nation could receive police services from the municipality. I understand that's currently the case for 2 First Nations. That's part of the status quo, and the proposal is that would remain there as an option. We are discussing a clarification. Right now there's some uncertainty, at least on the part of municipal police services boards. If a First Nation has territory within the boundaries of the municipality, and there is no other policing arrangement, is the municipal police service responsible for policing or not? That became a minor issue when Fort William First Nation acquired some land within Thunder Bay, and what would the default policing arrangement be there? The proposal is just to clarify that the municipal police service would have jurisdiction if there were not other arrangements in place. The second option, again, is a status quo option, and that's that the First Nation receive policing from First Nations constables appointed by the Commissioner of the OPP under Section 54 of the Police Services Act. Right now, all of the self-administered police services and all the Ontario First Nation policing agreement communities, or NPA communities, receive policing from First Nations constables. The requirements with respect to service delivery are set out in agreements between the First Nations, Canada, and Ontario. That would continue to be an option if that's what First Nations wanted. There might be some modifications as a result of Justice Tulloch's recommendations, particularly with respect to the SIU, although that's to be determined as part of the analysis of Justice Tulloch's recommendations. The 2 new options are options 3 and option 4. Both of those involve the designation of a First Nations Police Services Board as a police services board for the purpose of the PSA. One of the features of the current situation is that apart from Section 54, the Police Services Act does not apply to First Nation police services. Their boards, your boards, are not boards for the purpose of the Act. The officers are not considered police officers for the purpose of the Act. The regulations under the Act with respect to adequacy standards do not apply. The regulations with respect to training, use of force, the SIU, those don't apply. So, if a First Nation chose to receive policing under Model 3 or 4, the First Nation could approach the minister and ask to have a board designated for the purpose of the Act. With respect to municipal police services boards, we have rules about the size of the board, and a number of them, the members of the board are appointed by the province. The proposal is that those rules not apply to First Nations Police Services Board. So the size restrictions in the Act would not apply, and there would be no requirement, indeed any intention, that the provincial government appoint members to the board. The idea is that the First Nation would, or a group of First Nations, because this could be a board that provides regional policing, would propose the structure they want for their board, and for existing self-administered police services it may well be the existing board structure, and that would then be reflected in regulation, and that the appointments would be made as provided for under that regulation. With respect to the prohibitions on who can be a member of the board that Tiffany just presented, things like the current member of the police service, someone who practices criminal law, someone who's been convicted of prescribed offenses that would affect their ability to function as a board member. The proposal is that those restrictions would apply to all boards. So even though the composition of the board, in terms of number and who, whether it's representatives from this area or that area, that would be tailored for each First Nation board. These prohibitions, at least the proposal is, would apply to all boards, including First Nation boards. So under option 3, this board would maintain a police force in a manner generally similar to that a municipal or regional municipality maintains a police service. So the board would appoint officers. The officers would be officers, police officers for the purpose of the Police Services Act. The minimum requirements with respect to service would apply to this board. So if the adequacy regulation requires the ability to respond to calls for service 24 hours, 7 days a week, then that would apply to the police service maintained by this board as well. There would be one difference we're proposing with respect to these boards as opposed to municipal boards, and that is that there would be a duty for a First Nations board to consider how services could be provided in a culturally responsive manner. And the board would have a duty to consult with representatives identified by the political leadership of the First Nations when formulating those policies. So there would be that additional duty, but otherwise the duties are the same, coming up with the strategic plan, hiring the chief, appointing the officers, so forth. Right now, municipal police services boards receive their funding from municipal councils. If they're dissatisfied with the funding they receive from the municipal council, they have the right to appeal to the Ontario Civilian Policing Commission, OCPC, to have the funding reviewed, and OCPC can determine, for example, that the funding is not sufficient to allow the police service to provide adequate and effective policing. We're proposing a modified version of that for these self-administered police services boards, so that if they were dissatisfied with the funding available, if they believed that the funding did not permit them to meet the required standards of police service, they could appeal their funding. The proposal at AST was that they could appeal their funding to the Ontario Civilian Police Commission, OCPC, and OCPC could determine whether the funding was sufficient or not. Of course, First Nations police services are funded by both the provincial and federal government, and this is a proposed amendment to the Police Services Act. The province does not have the ability to impose financial obligations on the federal government. So the proposal is that this determination would really be a determination with respect to funding that the province would be obliged to provide. I think you can anticipate that if the province were ordered to provide additional funding, that it would then turn to the federal government and seek funding from the federal government so that it contributed its share of the required funding. But whether the feds stepped up or not, there would be an order against the provincial government requiring it to provide funding. I know this is familiar to many of you, that you've heard this presentation before, or you were part of the work to develop this proposal. But for those who haven't heard it before, are there any questions? Yeah.
Sorry, I feel like I'm talking too much, but there are some points that I think are important. Out of those options and approvals to the ministry, so opt-in, opt-out clause for a community that's already committed, let's say we commit that we are having a First Nations board under the new act. So then the community says to us, because we arrest the wrong person, that we're only OPP, because we hear this actually from the smaller community, not so much a bigger one because they self-manage that, but a smaller community might politically say, okay, we're opting out of a contract with you, we want to go back to the OPP or municipal police or whoever. If there would be nice to have a little bit of limitations written into it that if we're policing them, then they're going to stay policed by us, not flip back and forth between us and the OPP, because we spend a lot of time, with the OPP in consultation, trying to resolve the issues, and then it's quite a waste of resources to keep putting up with this depending on who we arrest in our smaller communities, not so much the larger ones. That's the first one. But second one, I wonder what the rationale you have, or why we don't have a provincial member on our First Nations boards, provincial appointed member. I think it's terribly important that we do, since this is about Ontario policing in Ontario, following the guidelines that are set out by Ontario and the things that you're mandating to other police services. And our First Nations boards probably don't understand the role that greater picture is with the province without having a representative there. I've also been on a couple boards where the politics overwhelm the management of the police service between the chief and the deputy, to think that a provincial appointee or representative or somebody that could help say, that's probably not the role of this board. I think that's an area that I think would not do us any favors by not having that. So what is the rationale behind not having a provincial representative there? For the ones that opt in, I mean, we're not talking about the ones that don't want it, because they're not coming anyway.
So I have been acting under the assumption that a provincial representative is not wanted. So if a provincial representative is wanted, then that's certainly a possibility. Nothing in the proposal would prohibit that. But I think the kind of outcome you're looking for might be achievable in a different way. So right now, every municipal police services board has a board advisor from the ministry that can advise on the board and help manage conflicts that might arise within the board. So if First Nations board were designated, then like a municipal board, there would be an advisor. And like members of the municipal board, board members would be provided with training on their role as board members. So hopefully with the training and the presence of an advisor, the kind of problems you described could be overcome. If there is a desire to have a provincial appointee, nothing precludes that.
So what is the goal of provincial appointee in a municipal or OPP environment?
So in a municipal environment, it's been there for a long time. I suspect the purpose was that the province didn't trust municipalities, although I'd have to go back and read the legislative debates from 1990 to determine that is why we have provincial appointees on municipal boards.
Because I think that it's important for those boards that choose to be under the Act to be similar to the point that that person's information is valuable. So where you think we might not want them, I don't know if that's the perception gained from the present board that want to operate like they do now, or from the new board that needs to understand adequacy and needs to understand the new system that's going to be in place. So as a member of a community, I would rather have knowing that somebody from the province is there. The advisor would not be a voting person, which is a little bit scary in some sense, because I've been in many in-camera, out-of-in-cameras in a hallway wondering what's going on there, because they don't understand the perspective of the meeting of what the issue is. It's more a political discussion than it becomes a governance discussion. So having a board member that's from the province there will probably help that to be a governance issue versus a political issue. So we're more sensitive to political issues in our smaller communities than might be in a bigger community. Same with rural Ontario, I'm sure it's the same thing you have to worry about in that sense. So that's that issue. And then the other issue is about 24-hour coverage or whatever the adequacy might be for the police services that go under the board. It would be actually a better option, or an option, not a better one, an option at the beginning to set up that because right now we don't have 24-hour coverage, it's just we don't have the staffing, and I know OCPC, we can go through that process maybe to get there, but in the beginning I think it'd be an opportunity for us to have that relationship with either the municipal police service or the OPP that backfill for us in that time when we don't have the coverage. So that allows us still to be First Nations policing, but and if OCPC says you can have X amount of people and we're going to pay you more, then we'd love to have our own, but we just can't fit it where we have an office of 4 people or 3 people working in the community. So it's a numbers game, I know, but that's where it's going to come down.
Right, so it's not something we propose to put in the Act itself, but we do anticipate that there will be a discussion about how services would be delivered and how to move from the status quo to a situation where adequacy standards were met as part of the designation process. So we have a proposed guideline which involves the First Nation making a proposal with respect to composition of the board, the communities that would be policed, territory that might be outside of the communities that should be policed by the First Nation Police Service, and how services would be delivered, and what services, if any, would be provided by another police service, either the First Nation Police Service or the OPP or the Municipal Police Service. So we anticipate there will be proposal, response, dialogue about that, and all of that will be worked out before the designation was made. But I don't want to miss your first question, which was about, I think I'm going to be cut off in a couple minutes. We'll have time to keep talking about this after. The question about communities sort of opting in and then opting out and going back and forth depending on sensitivities within the community. At AST, there was definitely concern about the stability of these arrangements. That's one reason why the arrangements might be unstable, another might be just a change in political provincial government. So we have some restrictions on the ability to change the designation board. And when a board's designated, it's designated to provide policing to a particular set of communities or territory outside the community. So if a community is dissatisfied, it's going to require a change in the board's designation to change the policing arrangement for that community. And what we've said is that the minister may only change a designation if there's a material change in the circumstances on which the designation was based. The minister has provided notice and opportunity to respond to the board and the communities before changing designation. And the minister has to consider the objective of First Nations determining the means by which culturally responsive police services are provided on their First Nations territories. That list is inclusive, so the minister has to consider those things, but that's not the end of what the minister can consider. I think stability of policing arrangements is also going to be something the minister would consider. And in fact, we've got a proposal in relation to municipal boards that municipalities want to change how they receive policing. They would require ministerial approval as well. And the minister would have to look at the ability to provide adequate and effective policing over the long term. So stability will be a factor in relation to municipal ministerial approvals. I think it will be a factor here. And I think if there's a likelihood that the First Nation will be opting back in a few years when there's a change in leadership in that community, then that might well mean that the minister would not change the designation and the First Nation would not be able to opt out, at least not immediately. If the desire to opt out persisted over time, then that might well happen. Okay. I do want to make a comment about Justice Tulloch's report and about the AST proposal. So the proposal was that, or included the ability of the First Nations Police Service Board to have its funding reviewed. It thought funding was inadequate to limit it to provide services at the prescribed levels. To OCPC, because right now municipal funding appeals go to OCPC. Justice Tulloch has recommended that OCPC no longer hear these municipal funding appeals. Now, obviously, he didn't make a recommendation with respect to First Nations funding appeals because he didn't know we were proposing that, and it's not in the PSA right now. We certainly think that the ability to appeal the funding is fundamental to the AST proposal, and that ability has to exist. The question is, who would hear that appeal? It could be that it would still be OCPC and that the government might not accept that recommendation from Justice Tulloch. Or it may be that a different tribunal could be identified to hear these appeals, although I don't know what that tribunal would be. Or it could be that the government or the chair of OCPC would create a roster of people who could hear these appeals, and that someone would be appointed from the roster. Or it may be that the First Nations Police Services Board could approach the OCPC and ask the chair of OCPC to appoint an arbitrator on an ad hoc basis, and the arbitrator would hear the matter. I don't know how this will end up. It is an implication of Justice Tulloch's report for the AST product, and we'll have to continue to have an appeal process. I'm just not sure about how exactly it will work.
Yeah, that's an important discussion to have. There's definitely going to have, in our opinion, there's definitely going to have to be some kind of mechanism in place. From what I understand from Justice Tulloch's recommendation was that the review systems in place were to focus on the important task at hand, and that was not to detract from some of the administrative parts, such as the funding mechanisms and such, but definitely I'm of the opinion that there's definitely going to have to be some kind of advisory, some kind of system in place to be able to get that information in place, removing it from that advisory.
So, I was just confused by the reference to advice.
Sorry.
Well, you were mentioning that the funding, if there was going to be any types of funding questions, that any of those from Justice Tulloch's review, he's recommending that that type of administrative function not go to OCPC, correct?
Yeah.
Yes, okay. So if it's not going to be going to the OCPC, then definitely there's going to have to be some kind of mechanism in place to
Yes.
have that dialogue and to have that conversation on where are we going to be having that type of discussion, whether it be through an arbitrator, as you suggest, or through some kind of advisory board.
So we definitely have to have.
A process to deal with this, to review the budget. The proposal at AST was not for an advisory body or a sort of dialogue. It would be an adjudication, right? That the board would make its submissions to OCPC. The ministry would be able to make submissions, and OCPC would determine whether standards were being met, whether the money was there to allow standards to be met, whether more funding was required to allow standards to be met. I should also add that in the AST proposal, OCPC was also to consider whether providing services in a culturally appropriate or culturally responsive manner required additional funding, and if that was the case, then they could order additional funding. Right? Not providing additional services, but providing the prescribed services in a culturally responsive way. Maybe it takes more time, maybe you have to bring in additional people, consult with members of the community before you process certain kinds of charges, things like that. That might cost more money, so that just has to be built into the budget. So OCPC was to consider all of those things and essentially render a judgment. And I think that still has to be the case, otherwise we're fundamentally changing the proposal that was agreed upon. And it may well be that OCPC will still be where it goes, and that Justice Tulloch's recommendation in that respect might not be adopted, but it might be adopted, and then there has to be some other way to get adjudication on the issue. Yeah, okay. Okay, so I might also note just briefly a few other issues related to Justice Tulloch's report. So option 3 on slide 32, I believe, has the First Nations community opting to receive policing from a First Nations Police Services Board. And it's essentially providing policing under the Act in a way very similar to that of a Municipal Police Services Board, which means the structures of the Act apply to the police service. Justice Tulloch is making recommendations that would fundamentally change the way that public complaints are dealt with. He's also making recommendations with respect to how the SIU operates, although I think those changes are less fundamental. But with respect to public complaints, he's recommending that the independent police review director, the what's referred to as the OIPRD, the Office of the Independent Police Review Director, would investigate all public complaints, and that if a public complaint was found to have merit, it would be referred to a prosecutor. The prosecutor would be someone employed by the Attorney General rather than the police service, and the matter would be heard before OCPC at first instance. So there wouldn't be hearings with respect to public complaints before a hearing officer appointed by the Chief of Police. This is not something we discussed in AST because we weren't aware that this was coming. I don't think that this proposal really affects the First Nation character of the services delivered or the ability to deliver adequate and effective and culturally responsive services to First Nations communities, but it is a significant change in the Act, and First Nations communities who are interested in opting into the Act would have to consider this proposal if in fact the government adopts these recommendations. There are also recommendations potentially with respect to licensing police officers. Again, I'm not sure whether the government will implement those recommendations. If they do, it's another change in the Police Services Act. I don't think it affects how services will be delivered in a culturally responsive way, but it is a change that First Nations communities should have in mind, because the Act that they would be opting into is not the same as the Act as it exists now, if these changes are, if these recommendations are accepted. Okay, so on to Model 4, or Option 4. Again, here the First Nation community has a police services board, but here the board is performing a function similar to that of a police services board for municipality under Section 10 of the current Police Services Act. So right now, a municipality can contract to receive OPP policing. If it does, it has a police services board. The police services board doesn't hire the officers, and it doesn't create a strategic plan, but it does participate in the selection of the detachment commander. It does create local policies for the delivery of services by the OPP, and it does identify, in consultation with the detachment commander, the priorities and objectives for policing the municipality. The proposal is that a First Nation community that wished to receive OPP contract policing could have a board, and its board would have similar functions, although we're proposing to change the functions a bit. So right now, police services have business plans, which will be changed to strategic plans, and the content will change slightly. The proposal is now that there will be a detachment level action plan to make the provincial strategic plan concrete with respect to how services were delivered in the local community from the detachment. And the proposal is that a First Nation that had a board would then participate in the development of a local action plan to have OPP services delivered to that First Nation community. It would also still participate in the selection of the detachment commander and still establish local OPP policies. There's also the possibility, although this has not been fully sorted out yet, that this local First Nation OPP board could in some way participate in the selection of the officers to provide policing to the community. It may be that the local board could identify criteria or qualifications that an OPP officer would have to have in order to be posted to provide policing to the community, and maybe that the local board could participate in some other way. We're still discussing this. In particular, we're discussing this with communities that are currently receiving policing under the OFMPA. So those are the communities that receive policing from First Nations constables, but the OPP is involved, very heavily involved, in providing administrative support to those First Nations constables so heavily involved that in some circumstances there's dispute as to whether these First Nations constables are perhaps in fact OPP employees or whether they're employees of the First Nation. So maybe some of these communities may wish to simply have an agreement to receive OPP policing, and then the question is, how will the local community participate in governance of the services, and will it be able to receive services from dedicated officers, and will the officers who are currently there be able to roll into positions in the OPP and continue to provide policing? Some of these are implementation matters that will vary from community to community, but we're trying to create a structure under option 4 where there could be a local board that would have a meaningful governance role where the OPP was providing services under a contract to the First Nation community. Any questions about that? Yeah.
Hi, Alan O'Keefe, Union of Ontario Indians. I'm not sure this is the exact spot that this question makes the most sense, but it's where I'm going to ask it. In relation to that, how do communities that are part of the Ontario First Nation Policing Agreement fit into that discussion? Like, you know, most of the discussion here sort of seems to be in the vein of, you know, the police services, like in our case, in the Shawnee Police Services, et cetera. So where do those communities rest in relation to how this, how they're affected by the changes to the police services after the proposed changes?
Right. So,
if they continue to receive policing under the OFMPA, and obviously there's a desire for communities to change the OFMPA or pursue other arrangements, but if other arrangements can't be worked out, then they would still have option 2, right, which is the appointment of First Nations constables under Section 54. So they could still have the First Nations constables they have as long as the OFMPA was renewed. They would still be receiving policing under the OFMPA. Now, whether the OFMPA is renewed depends on all of the parties to the agreement agreeing, Canada, Ontario, and I believe 19 First Nations. So it's always a challenge year to year whether that agreement gets renewed or not.
Assuming it is.
Mm-hmm. It's still an option.
Okay.
It's still an option. It's option 2. If they chose not to receive policing from a First Nation police service and they chose not to enter an agreement for OPP services, then you're looking at option 1, just go to direct OPP policing. They could opt to join an existing self-administered police service. If that police service doesn't opt under the PSA, then you're looking at a different version of option 2, right? Still First Nations constables, but it's part of a self-administered service. If the self-administered service exists under option 3 and they opt to join that, then they're under option 3. If they want a CTA, so a contract for OPP policing, where both Canada and Ontario are paying the cost of the OPP policing, then option 4 is there, and under option 4 they would have, we're trying to work out, but they would have a meaningful role in the governance of the services they receive, and probably they would have at least where numbers made it possible, they would have dedicated officers, perhaps in some cases the same officers they have now, but now a unit of the OPP rather than a group of First Nations constables employed by the First Nation. Does that make sense, or am I making it confusing?
Thank you.
You're welcome. Okay. If we could go to slide 33, I'd like to just comment on some themes that we've heard over many years with respect to First Nation policing and how the proposals are intended to address some of those themes. So one of the themes is that First Nations policing has to be culturally responsive. And the primary vehicle for making policing responsive to the local community, whether it's a municipality or First Nation, is the presence and governance provided by Police Services Board. So under options 3 and 4, we have First Nations Police Services Boards, and one of the purposes, the fundamental purpose there, is really to help promote cultural responsiveness. With respect to the option 3, the Self-Administered Police Services Board, we've proposed an express duty on the board to consider the cultural traditions of the community when developing policies. We didn't, in the AST proposal, impose a similar duty on the option 4 board. I think that was probably an oversight. Probably we just paid less attention to those boards, and so we didn't create an express duty there. I think it makes sense, subject to hearing otherwise from the communities, that one of these boards also have a duty to consider the cultural traditions of the community when it creates local policies or when it works on the local OPP action plan. We proposed at AST that if the Independent Police Review Director were investigating a complaint about a First Nation Police Services police officer, that the community, through the board, have the ability to develop its own dispute resolution process, and that the public complaint about the officer could be dealt with through that alternative dispute resolution process rather than through the IPRD process. Again, Justice Tulloch wasn't aware of this proposal, so I'm not aware that it's in his report, but certainly when we work with Ministry of the Attorney General on analyzing and looking at how to implement Justice Tulloch's report, I think we should be looking at alternative dispute resolution processes and allowing First Nations boards to develop their own processes. Justice Tulloch certainly anticipates that there would be alternative dispute resolution after a misconduct charge was laid, but I think there's the opportunity for culturally specific alternative resolution processes before the point that a misconduct charge is laid, subject to whatever the Ministry of the Attorney General might think. At the time we were working on AST, the Ministry of the Attorney General made a commitment to ensuring the cultural competence of the oversight agencies. There are now several recommendations in Justice Tulloch's report with respect to that, and given the Ministry of the Attorney General's previous commitment to that kind of cultural competency, I think there's a good chance that Justice Tulloch's recommendations will be favorably received. And we also at AST agreed on a new principle to include in Section 1 of the Police Services Act, which is the Statement of Principles, and I'll just read that. It was the need, and this is to apply to all police services, not just First Nations police services, that police services be provided in accordance with the following principle: the need to be responsive to the unique history and distinct cultures of First Nation people in Ontario. So that, in addition to the various diversity proposals with respect to municipal boards, hopefully will help promote culturally responsive policing, both from First Nations police services and other police services in the province. we heard over the years about the lack of substantive equality that self-administered services in particular were not able to provide a level of service that was comparable to that provided in neighboring communities, often by the OPP. So the adequacy standards, which currently don't apply to self-administered police services, would apply to the policing received by a First Nation community under Model 1, which is municipal or OPP policing, Model 3, which is self-administered First Nation policing, or Model 4, which is the CTA model, by making the adequacy standards apply. And by the way, the ministry is proposing to revise the adequacy standards and make them much more robust. Then First Nations would be assured of service being delivered at the level required by those regulations. The proposal to have the funding for self-administered police services reviewed, again, is intended to address the equality concern. I should add, although it's not something we finalized because it wasn't part of AST, it's something we're discussing with the OFMPA communities, and that is allowing them to have an appeal mechanism, not with respect to funding, but with respect to the level of service. So if they're receiving service from the OPP and there's a concern that the OPP is not providing service at a sufficient level, that it provides better service to the municipality that is nearby, then it would have the ability, whether to OCPC or a different body, to have the level of service it received reviewed, and this reviewing body would be able to determine and make orders requiring the OPP to provide service at a higher level if required. So again, this is to address the substantive equality concern that we've heard over many years. And then we also proposed in AST to add 2 principles to the statement of principles in the PSA that were with respect to the equality or adequacy of policing. So we're proposing that the statement of principles refer to the need to ensure that safety and security of all persons and property, including in First Nations communities, is protected, and also the need to ensure that all communities in Ontario, including First Nation communities, receive equitable levels of police services. So those would go into the Act as statements of principle. Statements of principles don't directly determine actions taken under the Act, but they would be principles that the minister would have to consider when deciding to approve a proposed board or to revoke the designation of a board, and failure to consider these would render the minister's decision susceptible to reversal on judicial review. And then a third theme in the concerns we've heard over the years is that First Nations policing is treated like a program, and there is a desire that it not be treated like a program. So again, having the adequacy standards apply to services provided under Models 1, 3, and 4 helps ensure that services are not being delivered at whatever level can be provided with money scraped together, but that there are minimum standards that would have to be met. Under Models 1, 3, and 4, officers could not strike. Officers can't strike under the PSA, and if First Nations policing is provided under the PSA, then those officers can't strike. The threat of the NAP strike last summer, again, raised concerns that First Nations policing was being treated as, or administered as a program, and not as an essential service. Essential service is not actually the term that's used in the PSA, but strikes are prohibited. again, the ability to have the adequacy of funding reviewed emphasizes this is not just a program that is dependent on the enthusiasm of one level of government from time to time for First Nations policing, but that there's a level that has to be met. There are guarantees there. And again, restrictions on the minister's ability to revoke designations were intended to help give First Nations police services more security and more status than simply being a transfer payment program. So are there any questions? Yeah.
What about the ability for the First Nation service to be part of a union
So
versus an association? Oh, I gotta repeat that. What about the ability of First Nations police service designated to be part of a union versus part of an association that they are under the Police Services Act?
So if the decision is made to go with option 3, then the officers would be prohibited from belonging to a union, and they would be able to form an association. Presumably they would. In our guideline, the transition from union to association and negotiating new collective agreements was identified as one of the implementation steps if a First Nation chose to have a board and have policing provided under the Act. So there's no intention to cause a crisis or disruption, and we anticipate that new collective agreements could be entered.
Right, so there'd be support from the government to create a collective agreement. Like, we're in the middle of collective bargaining, it's ongoing, seems perpetual anyway, with the union that's in place. But if we did this, then would there be support from the government to help us with that collective agreement, negotiating, bargaining, arbitrating, whatever it ends up at? And then we would appreciate it. We also appreciate the fact that it could strike, so that is really the main goal. But the next level of that is being part of an association, and then procedures that follow that, but it's expensive.
So I know that Treasure Board has been trying to promote coordinated bargaining by all police employers, right? So Treasure Board on behalf of the OPP, and then the municipal boards on behalf of the municipal police services. I expect that if there were First Nations boards would also be part of that coordinated bargaining initiative.
We need to be.
Any other questions? Okay. I think there are some formal questions on slide 34. Given that these formal questions have not been particularly successful at other sessions during the day, I don't know that I'll read them out. But if you do have any questions that you want to raise later in the afternoon, please do so.